rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140471, Shorey et al. Versus Arizona Corporation Commission. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client or clients that you represent. Each side will have 20 minutes for oral argument, and counsel for appellant is responsible for watching the clock on the podium and reserving any time for rebuttal that you might desire. We have read the briefs and we have conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Hurlin, you may proceed.
Bruce Hurlin on behalf of the appellants. The federal regulation S is what we call a safe harbor provision. It states what a person has to do to comply with regulation S, and if that person does so, that person's not going to get into any trouble. There's no registration required under regulation S. There's no disclosure required under regulation S. Shorey, or the appellants, complied with regulation S, and despite that, the status here today is that appellants are being held responsible for not registering the security when regulation S does not require registration, and the appellants are responsible and charged with selling securities as a non-licensed security dealer when these securities were sold in Europe, not in Arizona.
Is there any regulation under subchapter S of a corporation? Or are they just pretty much free to do whatever they want and really not have any body they have to answer for in regard to their conduct?
No, they're not free to do whatever they want.
Who is their monitor, overseer?
The United States of America, the federal government. There's an anti-fraud provision in Regulation S. And other than that, the law is very clear that the United States doesn't have any interest in protecting investors in foreign countries. Arizona doesn't have an interest in protecting investors in foreign countries, let alone plus states.
But Media Products is pretty clear that Arizona does have an interest in the corporations that operate out of its jurisdiction, isn't it?
They have an interest in the corporations. We're talking about a securities transaction from a corporation in Arizona in Europe.
Right.
And the ACC's taken the position that they have control over this transaction, even though the securities were sold to non-U.S. citizens in Europe.
Okay, so and I'm going to refer to it as a bridge, but the bridge I see you saying exists is that Arizona doesn't have the right to act, but the corporation has the right to operate from its jurisdiction. Jump outside the United States. Let's say that a fraud is being perpetrated against the people in Europe, and the only person that can get into that issue is the federal government. Is that your position?
Yes, absolutely. There's a big distinction here between interstate commerce and foreign commerce. The idea that Arizona can regulate foreign commerce. For instance, Arizona, when you come back from Mexico, Arizona is going to be there instead of U.S. Customs. This is a situation where the United States has acted and done so with instructions in Regulation S that goes back some time, and has said, here's what you do, and if you do this, you're okay. And it's a federal matter, and if there's an anti-fraud provision in there to be enforced by the federal government. Just like the federal government enforces counterfeiting, mail, the borders, immigration, this is a federal matter. And it's a federal matter because it involves foreign commerce. And that's a higher standard to get to. The idea of a state regulating something in foreign commerce is, I think, unheard of, except for this case.
But is it a state interest if it's a state-regulated corporation that is engaged in something that is determined by the Corporation Commission to be fraudulent?
Well, a couple of things in response to your question. First of all, there's an interest in the corporation, and I separate that from a securities transaction.
Define interest for us. Are
Well,
you talking about a financial interest? Are you talking about a practical or a legal interest?
You have to have a business license, you have to be incorporated, you have to file reports as a corporation, all sorts of things. Totally aside from a securities transaction. And in particular in this, appellants specifically relied on Regulation S. They knew Regulation S, they complied with it, and despite that, today they're being held liable for not registering when Regulation S specifically says you don't have to register it. How can Arizona get involved in a transaction where people in Europe are buying stock? That's Spain, England, primarily. Those countries have an interest in their investors who are Europeans, not Arizona.
Let me clarify something. I know you dispute whether these transactions occurred within or from Arizona, but if they did, then Arizona could, under the ASA, take action consistent with federal law, correct?
If the transactions were sold from Arizona
Well,
or to Arizona
if following
people?
the language of our state statute, if the transactions, I'm looking for that exact language, but if the securities transactions occurred within or from Arizona, then action under the ASA would be appropriate, irrespective of federal law, correct?
No.
Why?
I think that the federal law trumps that. When we're dealing
What kind
with
of
foreign...
preemption are you claiming? I mean, there are different kinds of preemption. What is your preemption argument based on?
On the Commerce Clause of the Constitution?
Well, those are two different things, preemption and the Commerce Clause. I mean, there's express preemption, there's
Okay.
field preemption, there's conflict preemption. What kind of preemption are you arguing?
I think that it's probably primarily conflict.
And what is the conflict that
That
creates the preemption?
That the Arizona's action here is nullifying Reg S.
So by conflict, you're saying that the one cannot occur, compliance with Subchapter S cannot occur without conflicting with what the Corporation Commission is doing in the state of Arizona?
Correct. The Corporation Commission cannot do this. It conflicts with Reg S. Like I said before, the appellants, in good faith, knowing Regulation S, comply with it, and despite complying with it, Arizona steps in. Now,
But United States Supreme Court precedent, basically on the issue of conflict preemption, says that absent an explicit indication by Congress of an intent to preempt state law, a state statute is preempted only, quote, where compliance with both federal and state regulations is a physical impossibility. We're not asserting that here, I assume. You're not
No.
claiming physical impossibility. Or where the state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. So you have to be relying on that. So how does the ASA registration requirement stand as an obstacle to the objectives of Congress?
well, as I said before, Regulation S says you do not have to register the security. Registration of a security is a very lengthy and expensive process that goes through lawyers, et cetera, et cetera. And there are many securities laws, both federal and state, that have exemptions because it's so expensive and time-consuming. This is one of the exemptions. And the reasoning for that is it involves foreign investors. You cannot sell to any U.S. investor, whether in Europe or in the United States. This was all done, and now the ACC is saying, despite Regulation S, you should have registered it. You should have paid that money. And you had to be a licensed securities dealer. And so the sellers over in Europe had to be licensed in Arizona. This is absurd.
Well, let's be clear about the people in Europe. The stocks belong to the people in Europe, and they were selling them there?
No, the Westcap was selling stock, but the Intuition were the people in Europe, and they were selling to the investors in Europe.
They were intermediaries. They simply
No, there were sellers. Under the law, there were sellers, clearly under securities law.
Okay.
I don't think anybody would doubt that. Now, I want to talk about the fraud here. The fraud that was alleged was that appellants didn't disclose the exact amount of the commission when Regulation S doesn't require that disclosure. And the private placement memo said that a commission was going to be charged. As in any time anybody buys any security, they're paying a commission. And according to the custom in private placement memos, that the private placement memo said, quote, normally paid in similar situations, end quote.
Okay, so who monitors and interprets normally paid?
Well, at the time of the private placement memo, it's unknown, because that's
What's unknown, the amount or the auditor?
correct. The amount of the commission that has to be paid.
Didn't they specifically delineate what percentages of the money that was paid was going to be put into
That was
what areas?
Yeah, his example was if $1 million was raised and the commission was 10%, there'd be $100,000.
So you're saying that was just like a theoretical thing, it really didn't apply or control what a buyer might interpret as being what was going to happen to their money?
Well, there was a number of questions, but no, I don't think it was a theoretical kind of thing. I think it was an illustration, an example of what the commission would be.
But how can that square with the facts that we've got 72.5% going off the top?
Well, first of all, it has to do with the disclosure. And the disclosure in the private placement memo was made based upon what information was available at that time. There was this example. Later, some time later, after Westcap tried to borrow money from hard lenders, the SBA, other people, they went to this company called Litchfield, negotiated something with them, and this was years ago when the economy was really in the tank. They went over to Europe and dealt with Intuition, which charged 65%. There were 24 investors. That's it. Who invested in this.
But those 24 investors came after the 72.5%
Correct.
figure was a known quantifiable amount taken off the top and
Correct.
not disclosed to the investors.
Correct. And I would add, following up that, is that all these 24 investors have been paid in full.
Paid in full what?
They were entitled to 8% dividends
On what?
on whatever amount they invested in.
On the 27.5% that was left after the 72.5% was paid to commissions?
On their principal.
My question is pretty clear.
Yeah, and I think,
On the 27.5% that was left after the 72.5% had been paid in commissions.
no,
They were paid on the whole 100%.
that's what I said. And whatever their investment was. They were paid in full, and
Not the issue under the law. The issue is the disclosure in advance so that there can be an informed purchase. So it's nice if that in fact is the case, but that's not really the relevant legal inquiry. is
well,
it?
I think has to do with materiality of all this.
After the fact, how can that be so?
Well, we have 24 investors who are not complaining, who have almost doubled their money, who got paid as promised, and so then we're dealing with this theoretical thing. Well, despite everything going well, despite Westcap doing everything right, despite the investors getting their money, we're going to penalize Westcap. And you talk about a regulation of foreign commerce here. The ACC, in their order, they want to cancel this investment. They want to give the money back to the investors. They want Westcap to pay money and cancel the investors, despite the investors being happy with their investment, give them their money back, and then also penalize appellants. I'm going to, if there aren't any other questions, I'll save my time.
Okay, thank you.
This is the most time I've ever saved.
Congratulations.
Good morning. May it please the court, Vaughn Paul Wynn on behalf of the Corporation Commission appellees. Originally I had 3 main points, but with the discussions, I have a quick 4 summaries and I'll discuss the matters in more detail. First question here is, can Arizona address fraudulent conduct occurring in its own backyard? By addressing only offer and sales that are occurring from Arizona by Arizona individuals, It's not violating the Commerce Clause, and it's not trying to address conduct wholly outside the state. Second,
What is the conduct it's trying to address?
the offers and sales of Westcap and Mr. Shorey, Justice Jones, those individuals were found by the commission order to have offered and sold the unregistered securities. They were here in Arizona at all relevant times. They submitted the offering documents to the investors. They received monies into their Tucson bank accounts, and they paid an 8% interest dividend from Arizona. Even in their subscription documents or their investment documents, it had a provision in those documents they gave to investors that the governing law and venue was going to be, and I think the quote is, hereby irrevocably consents and submits to jurisdiction in Tucson, Arizona. The conduct that the commission is addressing are the actual offers and sales of the Arizona entities and the Arizona individuals who violated the Arizona Securities Act.
Under the Commerce Clause, it seems like to me you may be drawing a bit of a distinction in your answering brief, saying basically as a matter of law, the anti-fraud provisions of the ASA are not incidental burdens on commerce, and then the registration requirements are treated a bit differently. Is that accurate?
It is, Your Honor. And as a result, we've seen at least two cases where they've looked at the fraud provisions of Arizona Securities Act and have concluded that it's no burden to interstate commerce. Traditionally, the courts have held that registration provisions, like blue sky laws of Arizona and other states, are just incidental burdens. And that's when we've talked about and discussed the Pike v. Bruce Church balancing test. And the question here is whether or not Arizona's interest, state and local interest, is an excessive and undue burden by requiring the respondents to register and comply with the law that's outweighed by our interest of not only requiring that registration, but preventing fraud in its own backyard. I hold that it is not outweighed by that.
And the media products case you believe is distinguishable. Give me the high points of why.
Yes, Your Honor. Media products and both Edgar v. Might are highly distinguishable because in both of those cases we're dealing with foreign corporations. In media products we had not only a foreign corporation, but they were dealing with all registered parties, registered underwriters, registered dealers, and they were registered federally with the SEC, and in every of the 12 states they were actually going to be offering the securities in. Here we have no registered parties at all. The respondents used a Colorado company and these individuals in Spain to generate leads, but it's their conduct that we're addressing, their offerings and sales and violations of the Securities Act that we're looking at and addressing.
So does the burden of the responsibility for any wrongdoing shift to the seller under any circumstance?
Your Honor, it may. There may be, fraudulent disclosures or possible requirements and registration requirements of those individuals, but that's not who we're looking to apply our Arizona state law to. Colorado may have violations in its own backyard they can address with their Colorado individuals. Spain or whoever overseas may have their own set of laws and regulations applying to those particular individuals operating in their own backyard. Where media products and where Edgar v. Might, I think, went and violated the Commerce Clause is because they were trying to apply a local state regulation to individuals that were not in their state. In Edgar v. Might, they were prohibiting a Delaware or Connecticut corporation to even do a tender offer, even if the people weren't even in Illinois. In media products, they only looked at the registration provisions, and they balanced that and said, what is your state interest here? You're not pleading fraud. You don't even have an individual in your backyard offering or selling securities, and they're registered, both federally and with every state. In their investment documents, they also clearly distinguished that it wasn't registered in Arizona. So even third-party investors would highly unlikely even look at Arizona.
Well, and in this case, we have a forum selection clause of Arizona. Was there a clause like that in media products? I don't recall.
Your Honor, I don't recall whether or not.
Do you place importance on that factor, that Arizona was the forum selection clause?
I do. I think it's as part of the totality of all the unique circumstances here that's distinguishable or different. That goes as part of the weighing of the factors.
Isn't it fair to say that media products is really specific as to what the failing was in that case? And that everything they point out as the failing appears to be in existence in this case. Isn't that a pretty fair statement? Do you understand what I'm saying? Isn't it just the flip side of media products? They're saying, aren't they basically saying, look, if it was what this case is in Arizona, then you'd have a complaint, you'd have an issue, but you don't have that in media products. Isn't that a fair statement?
If I'm understanding your statement correctly, Justice Jones, yes, they're so different and distinct that media products gave this court or gave us a framework and a unique set of facts that aren't applicable here, and that's why I don't think that the media products holding helps respondents in any way.
If you will, please, 17 CFR 230.802, preliminary note 4. I believe you cited it.
Yes, Your Honor.
It says nothing in these rules obviates the need to comply with any applicable state law relating to the offer and sale of securities. Nothing in that seems particularly confusing to me. So how do you interpret that in light of the facts of this case?
Your Honor, it goes back to the court's earlier question in regards to what is the conflict here that respondent is trying to raise. Under traditional Commerce Clause matters, there's usually either a state regulation that either is directly discriminating against a party or is impossible to comply with. Here the federal government has recognized, not only in Regulation S, but other sections of the federal laws, that state and federal securities agencies can work together in matters. In Regulation S, though they continue to present to you that they complied with it, the commission found they did not. It was their burden under 44-2033 to put facts forward that they complied with it. They failed that. They did not present any evidence other than that there were individuals overseas that invested in this matter ultimately. That was pretty much the extent of their facts to prove any exemption, whether it's federal Regulation S or any applicable state one.
But your position would be even if they did qualify as a Regulation S security offering, under the facts, under what's been prosecuted here, there would be no federal preemption.
Yes, Your Honor. And not only that, appellants go on and talk about there's no set requirement to disclose commissions in Regulation S. We look to, and in Aaron v. Fromkin, which is a Court of Appeals case here, it stated, look at what is material to a reasonable investor. And what the case law has interpreted is that excessive commissions are material as a matter of law. And they've looked at, and we cited cases where there were commission payments as low as 15% to as high as 75%, where the courts have stated that's so excessive that it's material to any reasonable investor that they'd want to know it. Also, under the federal securities law, under 15 U.S.C. 77 R.C.1, it expressly preserves the state's ability to address fraudulent conduct. Whether or not the security is exempt is immaterial. Federal government and the states can always address fraudulent conduct. So here we have a regulation that tells a party, you have to comply with our regulations, and they couldn't even put forward or did not establish what facts they actually completely met in Regulation S to even qualify, but they didn't even put forward how they complied with state law either.
So basically, in counter to the appellant's argument that the Regulation S doesn't require this disclosure, your point is that, well, the states can add additional requirements to prevent fraudulent conduct? It's read as what's material to a reasonable investor, and I think materiality takes the shape based on the facts and circumstances of the offering. For example, if we had say a biotech company who's offering shares and they went through a clinical trial for, say, cancer drugs,
and they failed and didn't get approval by the FDA, I think it's material that reasonable investors would want to know a material fact like that. The case law has adopted what's material in that fact and circumstance to a reasonable investor in that situation, because to put a laundry list of every possibility would be impossible because the circumstances are unique to each individual one. But when we've talked about excessive commissions, multiple cases have cited, in an unregistered offering like we have here, excessive commissions are so important because it really impacts the possible profitability that an investor may have. You've got to disclose it, and you've got to disclose it as material or as a matter of law.
Well, and I'm drawing a blank, but even numbers you mentioned, 15 to 75, there's a specific case that I believe refers with a certain amount of incredulity to the fact that they didn't think that a 30% commission was something that the investors needed to be advised of.
Correct, Your Honor.
2.5 times in this case, what in that case they kind of passed off as being something that couldn't even, wasn't even colorable as something that the investors should not have been told about.
Yes, Justice Jones, I believe that was the SEC versus Alliance leasing case where the Ninth Circuit went on to state the 30% commissions were so obviously important to an investor that reasonable minds cannot differ on the question of materiality.
There you go. Thank you.
Now, counsel has stated that investors were paid in full. If I understand that statement correctly, what I think counsel was really saying is that yes, investors got an 8% interest payment back to them. They did not get their principal paid back in full. I want to make that clear. And the fact that they state that they didn't know about these, commission arrangements. I think the argument that they presented at
who didn't?
The respondents weren't aware of the commission payments. What I think they mean by that, as brought out at the administrative level, is at the time the offering document was originally created, they were still negotiating the final numbers. But those final numbers were put into effect at or by the time that the solicitation started to occur.
Wasn't Intuition under contract when it started offering the securities?
Exactly, Your Honor.
Anybody buying in Europe from Intuition was dealing with a seller, as counsel refers to him, who had been contracted for at a 65% commission rate, correct?
Yes, Your Honor. And when we see them more as generating the leads for the respondents, because the conduct that the appellants would like to downplay, it's they're offering and selling from Arizona. There might have been additional offers and sales by these leads in Europe, Intuition specifically. That's not who we're addressing. That's not who we're trying to apply Arizona securities law to. I'll take any questions that this court may have.
Hang on just a second. Did the sellers, and when I say sellers, I'm using counsel's term for that, Intuition, did they have the latitude to negotiate prices for stocks or to vary the terms of a sale, or was it pretty much here's what we've got, you can buy it or choose not to buy it?
Your Honor, I believe it's the latter. They didn't negotiate anything. They just told individuals, hey, there's this company that solar company is offering stock. And then they would submit the contact information to the appellant, who then submitted all the offering documents, began communications, received the money, and they had a set price for the stock. It was $5 a share. That's what everyone bought in at. There wasn't a change or negotiation in that price.
So when I used the word intermediary earlier, in fact, they received with one hand a packet or a circumstance that they were allowed to communicate directly to somebody without altering, and that person would either accept it or they wouldn't on the terms that were proffered by the folks in Arizona.
Yeah, in general, yes, Your Honor. It was even more tenuous than that. They didn't even get the documents. They just passed along the information as they were soliciting and generating the leads. It was respondents who actually passed along the packet of information and documents.
I think that's all I have.
Thank you. In light of the cases that were discussed today and the evidence in the record, the commission decision is supported by the evidence and not contrary to law. I ask that the commission decision be affirmed. Thank you.
Thank you. Actually, did you get picked for jury duty?
I did not. I was there till 3, but I did not. Thank you.
I'll follow up on some of the questions you asked. I am not here to say that a 72.5% commission is a great deal, a reasonable deal, not a low commission. And that's not really the issue here on appellant's part. It's whether Arizona can do anything about that commission. It's very simple. They can complain about everything they want, but we get back to Regulation S and the Foreign Commerce Clause. And I think Judge Jones, you asked about registration. This is what Arizona's doing in this case. They're saying, okay, Reg S says you don't have to register it, but Arizona can add that on, and whatever else they want to. I submit that if you affirm this case, you're going to have to overrule Media Products. Media Products talks about how the principal place of business was in Arizona, the officers and directors were in Arizona, the stock certificates were prepared and issued by the transfer agent in Arizona, the board of directors meetings were there, and it does have a sort of a venue kind of thing. It says that notice pursuant to this agreement should be delivered to Phoenix. So we have the, and WestCap is an Arizona company. Shorey's the director, was the director, shareholder, etc. Every time you have foreign commerce, you have someone in the United States who deals with someone in a foreign country. If Microsoft or Apple want to sell cell phones in France, they have a contract with someone in France. They ship the phones to France. People in France ship the money back to the U.S. That's foreign commerce. And this is exactly what we have here.
But you were just talking about Media Products, and following up sort of on Judge Jones' question earlier, are you looking at Media Products? Do you have it?
Yeah, I have it right here.
Under Head Note 4, there are 6 factors listed, and I think maybe this is kind of what Judge Jones was getting at. There is one factor that is true here. Also, no sales were solicited or made to Arizona residents. But 1, 2, 4, 5 all seem to be, this case does seem to be the converse of what the court in Media Products found violative of the Commerce Clause. Media was a state of Delaware corporation. The brokers, dealers, underwriters were not Arizona residents. The purchase contracts were not made in Arizona. The offers were registered with the SEC and in the states. So Media Products to me doesn't seem to help you much. Why do you feel differently?
Because just going through the same ones that you did, the broker-dealer security offering sales were not Arizona residents, number 2. This number 3, they weren't made to Arizona residents, they're made to Europeans. The contracts, number 4, they were done in Europe.
That can't be. The contracts certainly were not finalized in Europe because the intermediaries didn't even have the contract documents to provide.
Once they found someone who wanted to invest, that contract document was sent.
By Mr. Shorey from Tucson.
Yeah, and it was finalized in Europe.
And when the money was paid to Mr. Shorey in Tucson.
Every foreign commerce has money coming into the United States. Just like I said with Apple, selling cell phones. When there's foreign commerce, there's always someone in the United States and someone in a foreign country. Every time, every single time. And this is exactly why it's in the Commerce Clause, because when the Constitution was written, they didn't want each state trying to regulate foreign commerce.
Tell me about preliminary note 4 that I referenced to
Sure.
counsel. Nothing in these rules obviates the need to comply with any applicable state law relating to the offer and sale of securities. And to the extent that you think that Arizona is preempted, what does panel 4, the comment on preliminary note 4 mean?
Well, I would say first that as Justice Scalia says, it's not law, and it may have been written by some staff attorney. If it was law, it'd be in the regulation. It's like someone writing legislative history. And secondly, there are certain things that I think that the state of Arizona can do regarding a Reg S offering.
What?
Excuse me. And this would be what would be termed as an incidental burden. And an example of that would be 1844, paragraph 19. And this is a part of the ASA, and it says if you're going to do an offering from Arizona, then you have to essentially notify the ACC and you have to pay $200 and say you're doing it. It's just, it's a provision and it's a notification. And it also has to do with offerings that are exempt from registration, where the offerer in Arizona just notifies the Securities Division that it's going on.
So, and you don't believe that registration is simply incidental?
Oh, it's very expensive. It's very expensive. You pay lawyers. It takes a lot of times. You have to get cleared through the SEC. It's a big project. I mean, this is where your New York lawyers make a lot of money registering securities for big corporations. It's a very expensive, time-consuming process. This is why there are exemptions from it, so that people, especially small businesses, don't have to, they can raise money and not have to pay that registration fee. I don't have anything for other than 20 seconds. 19.
Congratulations.
You can buy them back, counsel.
Yeah.
I'll roll that over for the next time.
All right. We'll remember that, I'm sure. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned.